Well, welcome everyone to my live stream session. Thank you for joining me. I'm Lior Samfiru, the employment lawyer. And the reason why I say employment lawyer is because you're on an employment law session, employment law live stream. This is the time, the place, and the location where you get to learn about employment law, workplace rights. Most importantly, you get to ask me questions about your job, your compensation, your boss, etc. Again, I'm Lior Samfiru, the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. You can find us across Ontario, British Columbia, and Alberta. So if you're one of those provinces, take advantage. Ask a question. Find out about your workplace rights. This is a live Q&A. I could just sit here and talk employment law all day, and I can if I need to. But I'd much rather talk to you, answer your questions, tell you what you need to know. Maybe you've been dismissed and you think it's a wrongful dismissal. Maybe you've had your job changed, your hours changed. Maybe your employer is not accommodating your medical restrictions or not returning you back to work from a leave. I think you get the idea. If you're dealing with an employment law issue, a workplace problem, this is the place and the time to get answers, to get the facts, to get the law, to know what to do, what to say, or what not to say. So if you're facing a workplace issue, ask your question. Let's have that discussion right now. I promise you there is no such thing as bad questions. There's no such thing as no answers, no solutions. There are solutions almost always. We have excellent employment laws, laws that protect you, that give you rights and give you options. Too many people don't know what those rights and options are. Well, on this session, you'll find out exactly what they are. So ask your question. Don't be bashful. And of course, let me give you some other contact information. Beyond the 30-minute session here today, if you want to connect with me and my team privately to have a private phone discussion or email discussion, so easy to do. You just go to employmentlawyer.ca. That address is on the screen right now, employmentlawyer.ca. And the phone number is right there. You can call. The email address is there. You press a button and send an email. You can fill out a form. And of course, you can also read a lot more about employment law and workplace rights while you're there. It's your one-stop resource for anything and everything employment law. But right now, I am live. I'm going to start answering questions here in a moment. Please ask your question as well. Sometimes people say, well, I was there, but I didn't know if I should ask my question. Of course, you should ask your question. What's the downside? The worst thing that can happen is you'll get an answer. You'll get some information and you'll feel better. Whatever that answer is, at least you'll know. All right, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I think I'm going to start answering some questions right now. Ask yours as you listen to me. Oh, this is a fantastic name. Our first question is from Psychological Fig. Come on, show me a better name than that. My company has changed my employment contract without any notice or communication. It was a drastic change in compensation. This new clause states that the company reserves the right to amend, modify, or update the policy anytime as necessary. With this clause, are they within the law to be allowed to make changes without myself or the employee being made aware of the changes prior? So the question is this, because you haven't given me a significant piece of information, is this new contract, did you accept it? Did you sign it? Or is they simply told you we're making these changes? It's very important because if you accepted this new contract that says these things, that's terrible, right? Because essentially what you would have done is given the company the right to do whatever they want, whether you like it or not. Terrible thing. You should never accept that. Because if you don't accept that, they can't do that. Your employer can't change your pay, change your job, change your hours. That would be a constructive dismissal if they did that. It's not legal. But they are allowed to do it if you've given them the right by signing an employment agreement that says that. So anytime your employer wants you to sign a new employment agreement all of a sudden, that's almost always bad news, almost always. It's going to have terms like this that allow the company to do all kinds of nasty things without your permission. It could potentially limit your future severance. It could give the company the right to put you on a temporary layoff. Again, things that they can't do unless you sign an employment agreement. So very, very important in this situation. Do not sign that agreement. If you haven't yet, please don't sign it. If you want me to see it, to advise you on it, send me a copy. Let me see it. Let's have that discussion, you and I, about that employment agreement. Okay, so, but the one thing I want all of you to take from this is, if you're working, you have a job, everything's fine, and then your employer comes in one day and says, hey, I want you to sign a new employment agreement, be very concerned. It's not trivial. It's a bad thing, and it's a big deal. All right. Hopefully that makes sense. Any follow-up questions, please ask me. Fantastic way to start today. Again, I'm Lior Samfiru, the employment lawyer. If you just joined us, this is my live stream session dealing with employment law. I see a bunch of questions have come in. You will all get answers. So stick around. I'm going to answer all of these questions right now. So take advantage. Next question from KS Wiz. I was employed as a software developer for 8 years, with over 2 of those years working in Canada. Recently, I was placed on the bench for about 2 months due to no available projects. Then, with just 1 week's notice, I was let go and offered only 2 weeks severance. Is this normal, or should I expect more severance? You're owed a heck of a lot more severance. So first of all, in this situation, all your years with the company count towards your severance. So it's not just the last 2 years that you've been working in Canada. If you were working overseas for this company for 6 years and then they moved you to Canada and you worked for 2 years, you're now an 8-year employee and you're owed severance as an 8-year employee. Now, depending on your job or your compensation, that could be 10, 12 months of severance. Absolutely, it could be. So you're offered 2 weeks. That's ridiculous. I'm going to take it a step further. Even if you would have only worked for 2 years, forget about 8 years, only 2 years, you would have still been owed a lot more than 2 weeks pay. You'd probably be owed 4 months pay, okay, maybe even more. So either way, this is a wrongful dismissal. You're owed more severance, and that's true for 90+% of people. When you're let go, regardless of the circumstances, it's almost a guarantee that the severance that you're actually owed is much more than what you've been given, much more. So for KS Wiz, it could be the difference between 2 weeks and 12 months. Huge difference. So KS Wiz, you got to connect with me through employmentlawyer.ca. Let's have that conversation. Again, employmentlawyer.ca, and I'll make sure you get everything that you're owed. Thank you for that question. By the way, yes, thank you. If you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live here with you answering your questions. A few questions have come in. I'm going to answer them right now. Please ask yours. You have so much time. You can take your time to phrase the question the way you want and type it in that box on the screen. Hit enter, and I'll read it and I'll answer it. All right, let's see. Next question is from Mitzi. Mitzi says, my mother is getting a lot of pressure from her employer about her retirement plans. She's 64. Does she have to tell her employer when she plans to retire? What are they allowed to ask about? So first of all, there's no such thing as mandatory retirement. She can work till 65, 70, 75, whatever age she decides. There's no ability to force someone to retire. That we got rid of mandatory retirement about 20 years ago in most places. So she can't be forced to retire. Now, even bugging her, harassing her, pushing her with this retirement, that alone could potentially be a human rights violation. It could even be a constructive dismissal. It's not appropriate. So here's what your mother should do. She should send an email, okay? Put this in writing. You can even help her draft it, saying, you've asked me a lot of questions about retirement. I'm not comfortable with that. I have no plans to retire. If and when that changes, I will let you know. That's it. That's all it has to say. If I will give it about an 80% chance that once she sends that email, they get off her back. If they don't, if they keep harassing her about it, well, should you retire? When are you planning? Why aren't you retiring? She needs to call me. Okay, I can help her get this resolved. But for now, Mitzi, I want her to send that email. Okay, it's a 2-line email. It's not more than that. Very simple. Send that email. You've asked me. I'm not comfortable with this. No plans to retire, and I'll let you know if that changes. Okay, so thank you for that, Mitzi. Make sure she sends that email as soon as possible. Any issues, problems, questions, concerns, reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic, excellent question, and I'm hoping everything resolves for your mother. All right, let's continue answering questions with me, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Ask your question as well. Listening to me, amazing. Asking me a question, even better. Abdullah has our next question. Hi, Lior. For overtime calculations and vacation, shall the bonus considered in the calculation when I'm fired? How about if I have 2022 overtime that was not including overtime? So generally, no, it won't be included in those calculation. But again, depending on the bonus, if it's completely discretionary bonus, it won't be. If it's not, if it's something that you count on as part of your compensation, then it does have to be included for those things as well. Best thing I can tell you is if you're not sure you're getting paid correctly, reach out to me, send me the info. I could do a calculation and figure out if anything is owed to you. The problem with this 2022 overtime is you may be out of time to pursue it. It is a 2-year limitation period, and if you're owed money going back to 2022, you may be out of time unless there's a reason to extend it, like they were telling you later on, we're going to pay it, and then and then they didn't. Maybe then we can extend that limitation period, but you may be out of time with respect to 2022 overtime. So Abdullah, if you want to reach out to me and have a private chat, easy to do, employmentlawyer.ca, the way to do that. Thank you for that question. Everyone else, you see how easy it is. Questions get asked, questions get answered. That's how simple we do this right here. So let's continue. I'm going to answer some more questions. In the meantime, you can ask yours as well. Don't leave here not having your questions answered. There will be a waste of an opportunity, right? Again, I'm Lior Samfiru, the employment lawyer. All right, let's see where we left off. Next question from unknown person. Okay. My company let me go after 18 months and said I violated the code of conduct, but I have a good record and never been disciplined. When I asked what code of conduct, they refused to tell me. Is that normal? Well, it's not normal, but the issue here is not whether they let you go, because a company can let you go for any reason as long as severance is paid. Where it becomes an issue is if they say, wait a second, because you breached the code of conduct, we can let you go and not pay you severance. That would be illegal. So for them to avoid paying you severance, they have to prove, number one, that you did something wrong. They have to prove it. You don't have to disprove it. And number two, they have to prove that whatever you did was bad enough that there's no way they could have just given you a warning, that they had to fire you. There's no other choice. Only in those circumstances, if they can prove those things, can they let you go without severance. That's why we call it termination for cause. But otherwise, they owe you severance. And even after 18 months, you could easily be owed several months of severance. You could easily be owed 3-4 months, maybe even more of severance. Okay, so unknown person, we need to connect off air as soon as possible so we can have that discussion and make sure that you get what you're owed. So the company, whenever the company alleges cause that you did something bad, they have to prove it. They have to provide the proof. You don't have to show that you didn't do anything wrong. They have to prove that you did. But even if you did something wrong, that in most cases is not enough to deprive you of severance. Okay, hopefully that makes sense, unknown person. If you have follow-up questions, take advantage. I'm still here. You can ask it right now, but I hope that makes you feel better. But you need to connect with me, okay? employmentlawyer.ca. Let's have that private chat. All right, fantastic questions I'm getting today, guys. Really, really great questions. So let's continue them. If you've just joined us, if you just clicked on here, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm answering your questions live about employment law, workplace rights, harassment, accommodation, bullying, wrongful dismissal, constructive dismissal, you name it. This is the time and place to get some answers. So let's continue. Mary Lynn has our next question. Employer is talking about needing staff back in office. Went remote during the pandemic. Employer said we'd stay that way. Now they're saying the opposite, but I have moved and can't be in the office. Can they expect me to return? If I can't, is it enough to claim cause? I'm very worried. So very, very, very good question. So here's what the answer is. They can't force you to come back. So if you don't go back, it's not grounds for termination for cause. It's not a resignation, none of that. Now, That said, they are allowed to let you go. Why? Because an employer can let an employee go pretty much at any time as long as severance is paid. So could they let you go with severance if you don't go back? Yes, they could, but it's a with severance. And I don't know how long you've worked there, but that could be worth many months' pay. What they cannot do is say, you didn't come in, so you've resigned. Nonsense. What they can't do is say, you didn't come in, we're terminating you for cause with no severance. They cannot do that. But what they can do is terminate you with severance. For now, what I would do is tell them, no, I'm not going to be able to come in because I've been working remotely for all these years. I've moved, not possible, so I plan on continuing to work remotely. They may back off and leave you alone, in which case, fantastic. If they don't, if you're out of a job because of it, call me ASAP, and I'll make sure you get what you're owed, okay? To connect with me, employmentlawyer.ca. That's how you do that. And Mary Lynn, hopefully that gives you the answer. Any follow-up questions? I'm still here, not going anywhere yet, right? So ask your question, any follow-up, and I'll be happy to connect again. Very common situation, by the way. Employees that have worked remotely since the pandemic, now the employer says, well, now we want to go back to the way things were. You have to come into the office. They can't do that, okay? You're allowed to say no. But keep in mind, the general rule, with severance, you can be let go for any reason. Your employer can let you go with severance because they think your house is too white and they prefer a house that's gray. You know what I mean? I'm being silly. Or that your car is not fast enough. That's dumb. But with severance, an employer can do that as long as, again, as full severance is paid. All right, fantastic question, and let's continue. By the way, before I take the next question, I've mentioned severance many times. I've mentioned it to Mary Lynn. I mentioned it to an unknown person. I want to tell you how you can find out for yourself in seconds how much severance you are owed. You may think, hey, I only worked for a few months. I'm not owed much severance. Or you may say, well, the company offered me this amount. They must be right. Well, how do I know the real amount? Very easy to do. You can find out in seconds how much severance you are owed. All you do is you go to pocketemploymentlawyer.ca. You see that address right there, pocketemploymentlawyer.ca. And when you're there, just click on the severance calculator. That's it. You can use our severance calculator like over 2 million Canadians have, and find out in seconds, how much severance you're owed. Maybe it's 10 months, maybe it's 20 months, maybe it's something completely different. You can find out at pocketemploymentlawyer.ca. By the way, I shouldn't have to say this, but just in case you're wondering, completely free, completely anonymous, no names, no email addresses, no company names, doesn't get published anywhere. It's just for you to have that information. pocketemploymentlawyer.ca. All right, I think we should continue answering questions. You still have time. I can guarantee you that if you ask your question now, you will get an answer on this session before it's over. All right, so take advantage. Little Mandrake has our next question. I drive a local delivery truck and was recently involved in an accident. The other vehicle was quite damaged. Can my employer fire me because of this? If I wasn't at fault, can I still be let go? Yes, you can. Remember what I was saying moments ago. You can be let go pretty much for any reason as long as severance is paid. So the company doesn't have to have a good reason, doesn't have to have any reason to let you go with severance. So if they say, you know what, we don't want this person here anymore, we're willing to pay them severance. As long as they pay you all the severance that you're owed, they can do that. What they cannot do is say, you got into an accident, we're going to fire you for cause without severance. That they cannot do. Okay, that would be illegal. But with full severance, and that severance can be as much as 24 months pay, they can let you go. All right, and that's almost always the case. When someone asks me, can my employer let me go? The answer almost always is yes, as long as severance is paid. The only times really when an employer cannot let you go is if if it's a human rights violation, if it's discriminatory. So if you're pregnant and they're letting you go because of that. They can't let you go because of your age or your disability or your race. That's illegal. That's a human rights violation. Beyond that, yes, they can let you go as long as severance is paid. So keep that in mind, little Mandrake. And if you are let go in this situation, you call me right away, because I can guarantee you that even if they offer you severance, it's going to be a lot less than what you're actually owed. So you got to connect with me if you lose your job, and I'll make sure you get everything that you're owed. Of course, employmentlawyer.ca, the place to go to get that help. Fantastic questions today, guys. You guys are really bringing your A game. So please keep it up. I want to get more questions answered. Next question is from Don John. Our employer has been installing security cameras around the office. Where are they allowed to place them? Are there any privacy violation they might be breaching? It feels weird to have them up. So generally speaking, an employer is allowed to put security cameras or recording devices, etc., in the workplace. They're allowed to do that. Why? Because in most cases, you don't really have an expectation of privacy if you're kind of out in the open. Where they can't do that is in places where you would expect to have privacy, in a change room or a bathroom. Obviously, that would be inappropriate. But if you're somewhere else on the employer's premises and they tell you that they're putting security cameras, they're not doing this in secret, they're allowed to do that, okay? And they're not doing anything illegal. And an employer that does that is well within its rights. So keep that in mind. And if there's any problems, you know what to do. You can reach me through employmentlawyer.ca. Okay, let's see. I have a follow-up question from unknown person. Unknown person said he was let go after 18 months because of violation of a code of conduct. So unknown person's follow-up says, they called me stupid, they threatened, they pre-warned us that they wouldn't use progressive discipline with us, which is against policy, but they also participated in body shaming, offered 2-week severance. Well, you know the answer, right? You know that you're owed much more than that, and you know you need to reach out to me. So that's the answer. You got to connect with me through employmentlawyer.ca. You're owed a heck of a lot more than 2-week severance. I'll make sure you get it. All right. Let's see. Next question is from Ricky Martin. Maybe the singer, maybe not. We don't know. Are new work policies enforceable when it's only directed for a few employees and not all? Well, generally, yes. An employer can have policies that apply to some people, but not to everyone. You know, maybe it's based on the type of job that someone has, or their seniority, or you know, where they work. So yes, generally speaking, if your employer has a policy, you should abide by the policy. Don't give them a reason to say you've done something wrong. And it's not a good idea to say, well, Bob doesn't have to do it, so why do I? You know, it's not fair. But we're not dealing necessarily in fairness, we're dealing in legalities. So generally speaking, if there's a policy and your employer tells you you have to abide by the policy, you should do it. Okay. Thank you for that question. Follow-ups, I'm right here as well. By the way, if you just joined us for the last few minutes, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And yes, I'm taking live questions here right now about employment law, about workplace rights, and you still have time to ask yours. So even last 6-7 minutes or so, you can still get your question answered. So ask it. You have time. Just like Blue Moon Gem, I was a contractor, quote unquote, without a valid agreement and created original intellectual property, including templates, apps, and internal systems. After being terminated, who legally owns what I made? What are my rights? So it's a great question. I take it that there's no agreement in place. You never signed any agreement at all. If you sign an agreement, the agreement may say who owns it. Generally speaking, if you create something for your employer in the course of your employment, it's they own it. Okay, generally speaking, if you create something that's not necessarily for them, but you may have done it in the course of your employment, then you may have a right to it. So we need to understand exactly what you created, who was it for, why did you do it, when did you do it? All those are relevant factors. But I want to focus on something else you said. You said after being terminated. Well, let's deal with that first, right? Because you're probably, you say quote unquote contractor, which means you're probably an employee. You've probably been misclassified, like most people that think they're contractors, which means you're owed severance. Okay. So let's make sure you get that severance that you're owed before we even talk about ownership of the templates. In fact, in the course of negotiating your severance, we may be able to get to deal with the IP and who owns that, and reach an agreement that they'll let you take ownership of it. So if you've been terminated, let's make sure you get severance. By the way, people get misclassified all the time. They believe that they're contractors, but they're really employees. If you have a regular job, you go to work, you do your job, you come home, you go back the next day, you're an employee. If you look like an employee and act like an employee, you're an employee, even if you call yourself a contractor. Okay? Happens all the time. By the way, we have a tool for that as well that allows you to find out if you're a contractor or an employee, if it's truly contractor or not. Again, how do you find it? You go once more to pocketemploymentlawyer.ca and you click on our independent contractor tool. See that address, pocketemploymentlawyer.ca? Click on the independent contractor tool there, answer a few questions, and you can find out if you're a contractor or an employee. If you're an employee, you're owed severance if you're let go. If you're an employee, you're also owed overtime, vacation pay, holiday pay, etc., etc. So it's important to know. All right, thank you for that question, Blue Moon Jam. Fantastic question, important one, very much so. Let's see, I say we take on a couple more questions if we can. Humble Bumble, another good name. I've been trying to return to work after a short-term disability leave. I do have some accommodations I need for now for my doctor, but I'm being ghosted. Is there anything I can do? Yes. So first of all, it's illegal to ghost you. It's illegal to ignore you. It's illegal to refuse to give you the accommodation. One of the most important legal obligations that an employer has is to provide that accommodation if you have a medical restriction, if it's supported by a doctor. It's under human rights legislation. Your employer has to do that even if it's hard. So if you've tried to contact your employer a few times, by the way, make sure it's in writing. Reach out to your employer in writing, email, text message saying, hey, employer, I've tried to connect with you a few times. I want to come back to work. I have these restrictions. Tell me when I can start. Put that in writing. If you haven't, they didn't respond, there's only one thing you can do. Let me reach out to them. See how quickly they respond to me. I guarantee you they will not ghost me. The moment they hear from me, all of a sudden, yes, of course we'll accommodate. Come back to work tomorrow. Everything is good. So if you can't deal with them yourself, they won't respond to you. Let me do it. See how fast that changes. But make sure you connect with them in writing. You don't want them to say, oh, you never did. We never heard from you. We thought you left. So very important to connect with them in writing. All right, let's see. Let's take one more comment or question here. Mitzi, who asked the question earlier. My husband has been classified as a contractor for years. If he isn't actually one, how does he go about getting that changed and getting vacation, etc.? Really only one way. He has to contact me. All right, and we can deal with that. And I'll talk to him about what his options are. He can reach out to me through employmentlawyer.ca. He may now decide not to do anything right now. It's up to him as to whether kind of he wants to rock the boat. But yeah, if he's legally been misclassified, he has rights and he has money owing to him, and I can help him get that resolved. So he can connect with me through employmentlawyer.ca, and I'll be happy to help him and at least outline his options for him. All right, everyone, I think that is the time we have for today. I've answered all the questions. I said that I would, and I did. Thank you so much for being here, for listening, for asking questions, for engaging, and for wanting to learn more about employment law. It's important that you have this information. I'm glad you had the opportunity to be here today. For now, if you want to connect with me to continue the conversation, or maybe you didn't get your question answered, easy. Just connect with me through employmentlawyer.ca. All the contact information you need is right there. I'll be back soon, but please don't wait. Employmentlawyer.ca is your friend. I'm Lior Samfiru with Samfiru Tumarkin, wishing you all the best, and we'll talk soon. Bye now.